So welcome to this short presentation on non-compete agreements. Um, this is obviously being supplied by Hayes Attorney PLLC. Just a quick disclaimer, this is just put forth for reasonable knowledge or common general knowledge and not necessarily per se for specific legal advice. Obviously, if you have a specific situation, you need to seek out legal counsel for that specific legal advice. The non-compete agreements, what are they? Non-compete agreements are legal contracts that prohibit one party from competing against another party so that party can protect a legitimate business interest which is not against public policy. And most of us have run into non-compete agreements as it relates to an employment context. They're usually done right at or near the time of employment beginning between an agreement is going to be between an employer and an employee. Those are the most common uses that where you'll see them. They are not to be confused with confidentiality agreements. Confidentiality agreements are also commonly used in an employment context where employers are protecting their information within their business itself, and non-compete agreement is protecting the business interests as it relates to competition. But other common uses that you're going to see, the non-compete agreement is also in the context of a sale of a business. A business is sold and the individual who buys the business is going to want the former business owner, the seller of the business, to be prohibited from competing against the buyer of the business. They don't want to buy the business and turn around and have to compete from the individual or business entity they just purchased the business from. You're also going to see them in shareholder agreements in closely held businesses, those that are not traded publicly, or not huge corporations, but basically small corporations. You'll see them there in the context of what were to happen if one of the partners was to leave the business, one of the major shareholders was to leave the business. How are we going to handle competition against one another in the future? And then you're also going to see them in a franchise or franchisee context. For example, Krispy Kreme or other types of franchises, you're going to see them there. So in a business context, the requirements or elements needed in order to have a valid non-compete agreement are threefold. One, they've got to be reasonable and necessary to protect the legitimate interest of the purchaser. In other words, they can't protect some sort of interest that is not related to the sale of the business, for example. B, they have to be reasonable in both time and territory, meaning a duration amount of time that the purchaser of the business or the seller of the business is not required to compete or not allowed to compete, and then a geographic territory as well, meaning that if it's a closely held business that only operates in the state of North Carolina, it would be unreasonable to protect the territory in the state of Virginia when the business has never operated in Virginia. And then finally, it does not interfere with the interest of the public. For non-compete in the employer-employee context, the elements are a little bit different as it relates to the North Carolina courts, indicating that one, it's got to be in writing, two, it's got to be made part of a contract of employment, three, meaning there's got to be valuable consideration. Again, it's got to be reasonable to time and territory and not against public policy. Let's take just a moment and flesh out the issue of the valuable consideration. So the simplistic idea of a contract is, for example, there's got to be mutual consideration. There's got to be an offer and acceptance for a contract to be formed. So in simple terms, for example, if I were to sell John Doe 3 apples, or offer to sell John Doe 3 apples, and John Doe were to pay me $3 for the purchase of the 3 apples, then I have offered John Doe something, he has accepted that, and then given me something in return, that being the $3. So for the 3 apples, there you have the consideration from both parties, you have the mutual consideration. So what the courts are saying here as it relates to valuable consideration for non-compete to be valid, that the employment has been considered, the employment, the receiving of employment itself has deemed to be valuable consideration. So that's why, if a corporation is doing this right, or if they're worth their salt, they're going to offer or request a non-compete to be signed at or near the time of the beginning of employment. In the event that the employer wants a non-compete to be signed in the future, subsequent to employment beginning, and the employee already works for the business entity, then there's going to have to be an additional consideration given in order for that non-compete to be valid. So if there's nothing given in return in that situation for the employee to sign the non-compete, then the non-compete is basically not valid. It's not binding because there is no consideration given. Because the employment has already been given, and there would have to be something in addition to the employment after it has already begun in order for the non-compete to be valid in that context. And the courts have said nominal or token consideration will not be enough. It's got to be valuable consideration. So, for example, in a context where employment has already begun and then someone was offered opportunity to earn commissions, the court specifically in that context has said no, that is not sufficient consideration, and the non-compete would not be valid in that context. Also, in shareholder and operating agreements, operating agreements are going to be, when that are implemented at the time the business is incorporated. If you're going to have more than one partner in that business entity, it would make sense both for the value of the business and the protection of the business to consider non-compete and its context, and in the event a shareholder or one of the partners was to exit the business, how are we going to handle the competition going forward? So that's something that you definitely want to consider when you're considering the drafting of an operating agreement, whether it be simply a limited liability company, S corp, or C corp if it's closely held business. A case example: two home health care companies. For example, I believe this was in Moore County, North Carolina, in 2016. The covenant in question prohibited employees from working for, providing services for, consulting with, or otherwise assisting in any individual or entity who is the home health or personal care business competing with the employer. So the question is, this obviously appears to have either been taken from a form, or maybe even a counsel, an attorney had drafted this on behalf of one of the business entities, and now there's competition, and one of the business entities is seeking to enforce the term of this non-compete. So how does the court answer this question down there in Moore County? You're going to see here that the non-compete term was very broad, and it was found to be overly broad and unenforceable. Why? Because it did not protect a legitimate business interest. It overreached in that business context. So every non-compete has got to be specifically tailored for that specific business interest, and to make sure that you do not overreach, because if you overreach, you could end up getting in this simple position here, meaning that the term was unenforceable and the competition was allowed to go on anyway. So the court held here that covenants that restrict an employee from working in any capacity providing services of any type to competitors and are not restricted to prohibiting the employee from performing the same type of work or services is unreasonable, and the court is most likely not going to enforce that term. So the main lesson learned, I think, for this short presentation as it relates to non-competes is don't use a form. It's very easy to fall into that mindset and think, well, I can do this on my own. LegalZoom, right? Be very careful and think it through. So what's the cost of, when you think about these things, if it's something that you do not have direct experience in and exposure and litigating the court process and researching these issues as a business owner, both in employee and employer context, think about what the cost could be in the event that it's not done properly, and think about the minimal cost that it's worth to have it done right. Thank you.